Let's go back on the record, please. I do have some preliminary remarks before I impose sentence, so I will ask you to stand at the appropriate time. All right, well, as everyone knows, we're here for sentencing. I received and I accepted the verdict of the jury on the 2 counts of tampering, so we're not here to relitigate that. I'm not going to go behind that verdict. Today is all about sentencing. Since the day that you were convicted, Ms. Barrientes Vela, I have weighed all the evidence in this case. I have thought long about the credibility of some of the witnesses that came forward, and all of that I considered in preparing this punishment. I've heard the arguments of both sides of the attorneys. Thank you both sides for your excellent presentations throughout this whole trial. I read the pre-sentence investigation report. I read the victim statements that came through the pre-sentence investigation report, and I read the results of the TAP evaluation. And in thinking about your punishment, Ms. Barrientes Vela, I have considered the circumstances, the nature of the circumstances. You know, in criminal courts, we hear blood, what I call blood and guts. Blood and guts, sex offenses against children, family violence cases. We hear drug cases, robberies, anything about guns and drugs together, dishonesty cases, and cases of public officials, which is what you're here for today. So what is this case not about? It's not a blood and guts. Nobody was physically injured. There's no child that was hurt. There was nothing egregious about the nature of the circumstances in this case. However, there was a lot of evidence about threats and intimidation and hostile work environment and things that different witnesses described that stem from your elected position. I heard many witnesses refer to you with a lot of contempt in their voice, a lot of disrespect in their voice, and maybe the record didn't capture it for the Court of Appeals, but I heard it, and I considered that in assessing their credibility. I also have to think about the seriousness of the offense, right? And the reason that I have to consider that is because we live in a country that is governed by the rule of law. Laws are important. Respect for the laws are important. And sadly, in this case, that was seriously lacking. Not only by you, but I saw that from some of the witnesses too. In fact, one of them walked away with a dismissal. And so I need to make sure that whatever I issue today continues a pattern of just having respect for the law, because that's the country that we live in. I also have to consider whether I need to protect our community, right? I'm not concerned about that. You are no longer an elected official. You will no longer have, our community will no longer be at risk in that regard. I have to consider your history and your characteristics. You know, it's interesting when anytime that we get to punishment, you know, people want to give judges ideas on what to do, and I don't think they've ever read Section 42A of the Code of Criminal Procedure, and that requires us that we give a sentence with the best interest of justice, the public, and the defendant. So I have to consider your life, your contributions. And I have to say that I liked Richard James yesterday, and I liked your sister-in-law. I liked what they said. I can tell you are loved and respected by your family and supported. And I do believe you have strong ties to your community. I do believe your husband and you have created a business that works for you. So what is available to me as a sentence? Well, straight out prison, shock probation's available, straight probation with no jail sanction, and probation with a jail sanction. And today my sentence will be probation with a jail sanction, and this is why. Shortly after Moreno was arrested and released, you gave a press conference, and my concern has been your actions after he was arrested and released. Because in that press conference, in front of the courthouse, you said yourself, I don't answer to nobody. I am the elected official. I am the top boss in the whole office currently right now. Those were your words. And so, as the top boss of Precinct 2, I expected you to tell Garcia that arrest was illegal and call it what it was. So when your attorney tells me today that you simply believed Mark, I don't believe that. I don't buy that. I think that you had the opportunity to distance yourself from that as the top boss and tell Mark Garcia that is wrong. And so you had this awareness of the illegal conduct, and instead of doing something about it, you continued to avoid it and instead persisted that he get prosecuted. And you did so in uniform in front of our county courthouse with supporters with signs trashing our elected officials, our county leadership. So if citizen Michelle Barrientes Vela wants to do that out of uniform and trash the county leadership, that is citizen Michelle Barrientes Vela's constitutional right. But you were in uniform with your entire command staff. And so that does not show me as the judge that you had good intentions with regards to the illegal arrest of Moreno. That shows me the opposite. So the sanction that I'm going to issue will be as follows. If you could please stand so that we can proceed to sentencing. Mr. Goss, is there any legal reason we cannot proceed to sentencing?
Oh, yeah.
It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, the Institutional Division. That will be suspended. You will be placed on 5 years probation. There's a 25 fine.
Come on.
Close the door.
I did not hear.
I'm going to start over. Okay, I don't want anyone else to come in, so please don't let anyone else in. Okay, I will continue. I will start over. It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, Institutional Division. That will be suspended. You will be placed on probation for 5 years. There's a $2,500 fine plus court costs. No restitution is ordered in this case. You will be ordered to satisfy 600 hours of community service. 1/2 of those hours I will allow you to buy out by contributing to the San Antonio Food Bank at $10 per hour. The remaining 300 hours you will satisfy by working for Habitat for Humanity at a location I will designate. There is to be a no contact order with Leonicio Moreno, no contact order with Anthony De La Cerda. I am ordering a $50 contribution to Crime Stoppers. I'm also ordering a moral recognition therapy course. You will complete that course. I will be satisfied if you buy the workbook yourself. I'm not going to require you to go to the group therapy sessions. Confinement, as a condition of your probation, 90 days confinement in the Bexar County Jail. I am going to hold that in abeyance until the results of the appeals are exhausted, but I am ordering it, I'm imposing it once all of that is finalized, and I will decide how you will serve that confinement. I have options. Ms. Barrientes Vela, this is a plea bargain case. I'm sorry, this is not a plea bargain case. This is a trial case. You have the right to appeal both the judgment of conviction by the jury and the judgment of punishment. Lastly, your probation starts today, ma'am. Look at me. Your probation starts today. You have certain appellate rights with regards to a motion for new trial, a notice of appeal, and until I receive in this court a notice of appeal and a request to not go forward with your probation conditions because your appeal is pending, you are on probation as far as I'm concerned, and you're required to comply. And it is up to you if while your appeal is pending, if you want to continue with your conditions. If you don't want to, the law says you can stop, but you will resume as soon as that mandate returns. If everything is affirmed, you start off where you left off. But for purposes of today, you start your probation with me today. I don't have to tell you, I take probation very seriously. I don't mess around with probationers. No reports from you are the excellent reports I want to hear. That you have been a model probationer is what I want to know. I want you to have a seat. You have to sign your conditions of probation, and I will give you the trial court certification of notice to appeal. Now, this is how we're going to evacuate the building. I need to make sure the hallway is secure, and if not, if Mr. DA, if you can go through the back, probably a better.
Your Honor, and we do have a notice of appeal that we would like to tender to the court at this time. We do understand, and I will communicate with our appellate counsel, that you also want an intent, further intent about what they plan to do or what he is advising should happen. Since after this point we're going to ask for a motion to withdraw, Mr. Gross will be her counsel for appeal, and he will be communicating with the court.
I would hold off until her appellate counsel files that. I would file that today if I were you.
He asked me to file it today.
I understand, but there's other things that he needs to come and talk to me about before that notice of appeal.
I understand.
The motion for new trial is due first within the first 30 days of my plenary power.
Yes, Your Honor.
You have the right to file a notice of appeal within 90 days of today if you file a motion for new trial.
Yes, Your Honor.
So if you file that notice of appeal, you're going to cut yourself some time off significantly.
Yes, Your Honor.
So please consult with appellate counsel before you do that.
Yes, Your Honor.
That is all I have this afternoon. We are at recess. Don, you're not going to give me the assistance today, right? I'm not going to sit at trial.
Yeah, Judge. We got to do
Take
it.
it up.
Thank you.